Lori, we ready to start?
Yes, thank you, Dan.
Great. Welcome, everyone. My name is Dan Schlesinger, and I'm the chairman of the Board of Governors of the Hebrew University of Jerusalem. I'm very pleased to introduce the sixth and final presentation in this CLE series, sponsored by the American Friends of Hebrew University in partnership with the American Association of Jewish Lawyers and Jurists. Today's topic, Copyright and the Holocaust, is presented by Professor Michal Shur-Ofry, a member of the Hebrew University Faculty of Law and head of the faculty's research committee. Professor Shur-Ofry's presentation, which is based on a large-scale research project she conducted with her colleague, Professor Guy Pesach, examines the complicated relationship between copyright law and the Holocaust. She considers whether ordinary copyright protections should apply to works created by Holocaust victims, as well as the documentation and propaganda generated by their Nazi oppressors. Copyright law and the Holocaust are among the many areas of study and analysis that can be found at the Hebrew University Faculty of Law, located at the Mount Scopus campus. The law faculty was established in 1949, the first such faculty at an Israeli university. Proud to count numerous Supreme Court justices, attorneys general, Knesset members, and leaders of the profession among its alumni, the Faculty of Law has earned an international reputation for excellence, coming in at 30th in the 2021 Shanghai rankings of law faculties. Shanghai also ranks Hebrew University overall at 90th in the world, which is top 5% and #1 in Israel. American Friends of Hebrew University is proud to team with Hebrew University in bringing you this terrific lecture series as part of our efforts to spotlight and support the academic excellence, cutting-edge research, and dynamic innovation for Israel and the world. Now, please, Professor Shur-Ofry, the floor is yours.
Thank you very much, Dan, for the introduction. I'm very pleased to be with you this afternoon, your time, and to speak about copyright and the Holocaust. Let me just share my screen. Okay. As Dan was saying, by way of background, this talk is based on this large-scale research that I have been conducting during the past years together with my colleague, Professor Guy Pesach. And this research is funded by the Israeli Science Foundation. And here you can see the team of researchers, of research assistants that have been working with us on this project during these years. And in this slide, you can see the publications that emerged so far out of this project. If anyone's interested, they're all accessible online on SSRN, and there are more to come. And if we have time and you'd be interested, I'd be happy to say a few words about the different strands of this research. But today's talk, as Dan was saying, will concentrate on the most general theme, which is the impact of copyright law on the collective memory of the Holocaust. By collective memory, again, just to touch base, we refer to collective memory in the sociological sense. It's a term coined by sociologist Maurice Halbach to refer to the joint recollection of the past by nations, by minorities, by other groups of joint identity. And the idea here is that our memories are not only a product of our own individual experiences. Rather, memories are also a product of social construct, and they are influenced by the groups to which we belong. So I imagine many of us would say, for example, that we remember the Holocaust, although we did not personally experience it, and probably were not even born when the events occurred. So the Holocaust is perhaps the most paradigmatic example in the literature, in the sociological literature, for the construction of collective memory. And our argument in this project, in this research, is actually twofold. First of all, on the descriptive level, we wish to illuminate the largely unnoticed role which copyright law plays in the construction of the collective memory of the Holocaust. Copyright law, as you probably know, is a branch of private law which protects musical, artistic, literary, dramatic works, and by giving their owners, the owners of copyright, the creators usually, the exclusive power to control their works. So what does copyright law have to do with the Holocaust, with the memory of the Holocaust? So this is the first part of our argument. We argue that it does affect the collective memory of the Holocaust in various ways, which I'll describe. But we are also, as lawyers, make a normative argument. And the normative argument is that since copyright law was not designed to handle extreme circumstances as the circumstances that existed during the Holocaust, when we apply ordinary copyright law to those extraordinary circumstances of the Holocaust and to Holocaust-related materials, then this application results in all sorts of conflicts and tensions and distortions, which are socially harmful. And we make some recommendations of how to mitigate these dissonances. But before I delve into the details, let me just give you a sense of what the Holocaust-related materials which we discuss are. So I'll begin with one example, and then we'll move on to some more examples. The first example is the history of the Kovno Jewish Ghetto Police. So in 1964, construction workers that were working in Kovno, Lithuania, accidentally exposed a crate that was buried in the ground. And inside the crate were thousands of documents. Among them was a 250 pages manuscript that was titled The History of the Kovno Jewish Ghetto Police. Now, the history was secretly written by members of the Jewish police that operated in the Kovno ghetto during the years 1941 to 1943. It describes in great detail the events that occurred in the ghetto during that time and the gradual decline of the ghetto and its population. And in the first pages of the manuscript, its authors describe their objective. And they write, "It's impossible at this time to sum up and to achieve what might amount to a comprehensive description of life in the Kovno ghetto, or provide a summary of the activities of the ghetto institutions. To this day, we are still regrettably in the midst of the event. But in any event, the future historian will find here sufficient verified material of the history of the Kovno Jews in the gruesome years of 1941-1942. And this is the most important objective of the lines that follow." And then a few pages later, "If we should not survive, then perhaps the document we're writing here will fall into the hands of Jews who will read and be astonished by what was done to us in the gloomy ghetto." So clearly they were writing for the future. And indeed, in all likelihood, the authors of this manuscript did not survive, because we know that the members of the Jewish police were executed in the ghetto in 1944. But before then, when the liquidation of the ghetto became apparent, they took the manuscript and the entire police archives, put them in a crate, buried them in the ground, where they were accidentally found 20 years later. And it took another 30 years or so before the manuscript and the materials became accessible to the public. So the manuscript is one example of out of a huge number of works that were created by victims during the Holocaust. And these include letters and diaries and drawings and photos and music created in ghettos, in concentration camps, even in extermination camps. So here you can see, for example, the part of the music sheets of the opera, The Kaiser from Atlantis, that was written by Victor Ullmann and Peter Kiel, two very well-known artists that were imprisoned in the Theresienstadt ghetto. Here on the left-hand side, you can see photos taken by Mendel Grossman, a photographer that operated in the Lodz ghetto and documented life in the ghetto and the decline of its population, including, you can see here, the photographer's own family. Here you can see documents, drawings, autobiographies that were found in various semi-structured archives that operated in several ghettos and intentionally collected and composed manuscripts, commentary, photos, drawings, materials that would document the life in the ghetto. So there's a very famous archive called the Onek Shabbat archive that operated in the Warsaw ghetto, but there were archives in additional ghettos as well. And like the history of the Jewish police in the Kovno ghetto, all these works were produced during the Holocaust as acts of commemoration. Their purpose was to bear witness to the tragedy, to impact the memory of future generation, to document a community and a culture that were being eradicated, to affect the memory of the future. So these are some examples of these enormous amounts of victims' work, out of the enormous amounts of victims' works created during the Holocaust. And on the other side, there's also numerous Holocaust-related materials that were created by the Nazi regime and their collaborators. So these include monographs written by prominent Nazi leaders. So of course, the most famous of which is Hitler's Mein Kampf, but there are also the Goebbels diaries, the Himmler's diaries, the Eichmann's notes, prison notes, which he wrote during his imprisonment in the Israeli prison, and many, many more. There are Nazi propaganda films, the most famous of which is Triumph of the Will, which was produced during the 1930s by the acclaimed director Leni Riefenstahl under the instruction and the supervision of Hitler himself. But there's also a huge amount of materials documenting systematically the entire process of extermination in photos, in video footage, in written documents. Now, as some of you may know, copyright is a right that is limited in time. Usually, copyright expires 70 years after the death of the author. So the first question we have to ask ourselves, because more than 70 years have lapsed since the end of World War II, does copyright still subsist in those Holocaust-related materials, or is this thing a thing of the past? So the answer, the short answer is that yes, it does. First of all, as far as the Nazi materials are concerned, the authors often survived the war. So copyright will expire in many occasions only in several decades. As far as the victims are concerned, many of the victims' works were created by anonymous people and were not published by their authors, but rather concealed, like the history of the Jewish police in the Kovno ghetto. And under this very complicated web of provisions, under United States copyright law, in such cases, copyright extends to 120 years from the creation of the works, which means that these works are also protected by copyright for decades to come. So given these copyright protected materials, does copyright affect the collective memory of the Holocaust? So the first basic answer is quite simple, actually. Copyright gives its owner private control, exclusive rights, private control over the access to and dissemination of the works. Now, collective memory is constructed, at least partially, by access to those materials, to authentic materials. Because copyright law awards those private parties, those copyright owners, with control over access, then it affects the collective memory of the Holocaust. But of course, this answer is quite general. It doesn't only apply to Holocaust-related materials. It's not unique to Holocaust-related materials. This is how copyright operates. But we argue that in the case of the Holocaust, copyright law's effect is intensified, effect over the collective memory is intensified due to three combined reasons. The first is what historians call the Holocaust's problem of representation. Now, the problem of representation implies that because of the extremity of the genocide, because of the radicalness of the Holocaust, we today, or ordinary people today, cannot, or it's very difficult for us to perceive the Holocaust as a reality, as something that actually happened. And one of the ways to mitigate this problem of representation is by giving access to authentic materials from inside the event. So once copyright controls this access to authentic materials from inside the event, then its effect on the problem of representation and on the way we can perceive and understand the Holocaust is significant. The second reason for copyright's especially significant impact over the Holocaust's memory concerns the role of remembrance institutions in constructing the memory of the Holocaust. And by remembrance institutions, I mean museums, archives, libraries that are dedicated to the preservation of the memory of the Holocaust and of Holocaust-related materials. And usually these institutions are the only places, the sole places where people can access Holocaust-related materials, because many of these materials, like the small letters and the mirrored photographs and lists and drawings, do not have a real market outside the Holocaust museums and remembrance institutions. And those remembrance institutions would normally be non-for-profit institutions, and their policies are likely to be very risk-averse, in the sense that even a small risk for copyright infringement may make them very hesitant to act or to grant access to certain materials. They would wish to avoid the risk of copyright infringement. And we can see here an example, part of a testimony of a representative of the US Holocaust Memorial Museum in 2008 before Congress. And this representative describes that the museum holds masses of photos, anonymous photos from the Holocaust. And she explains that these photos will not be made available to the public unless the museum assumes the risk of a copyright infringement. And even though these risks may be minimal, they're not ones we can responsibly assume, and they have a chilling effect on all our decisions regarding the use of orphan works. And the third reason, the third related reason for copyright's large effect on the collective memory of the Holocaust is that the entire copyright algorithm, as we call it, not algorithm in the sense of software, but algorithm in the sense of copyright law, the way the law is constructed, the way the doctrine is constructed, is not designed to deal with extreme circumstances of genocide. And therefore applying it to Holocaust-related materials creates all sorts of theoretical, doctrinal tensions and distortions. Some of them may be unique to the Holocaust, others may exist in other circumstances, but again are brought to the extreme in the case of the Holocaust. So we try to map those principal points of friction and dissonances, and here I'm going to delve a little deeper into copyright doctrine. So first of all, I have to show you the first code word. So there you go, surprisingly, copyright. Okay. So, so what are the principal tensions here between copyright doctrine and the Holocaust memory? So first of all, there are conflicting narratives, as we call them. The most fundamental narrative underlying copyright law is a market-based narrative. So copyright is granted to creators in order to incentivize them to create by providing them with exclusive rights, which will enable them to profit from their creations. But when we look at works that were created by victims during the Holocaust, here this meta-narrative of incentive for creation, control, monetary incentives were largely irrelevant. On the contrary, the ultimate goal of the authors was not to control these materials, but rather to disseminate them in order to voice the Holocaust to the world. There was a real fear, a real sentiment that really comes out of these materials when you look at them, that the world will not know what actually happened because the entire community will be eradicated. So the idea in creating the materials was to voice the Holocaust to the world and affect the memory of future generations. It had nothing to do with monetary incentives and control. And the history is one example. And here you can see another example. This is a note that was written by David Graeber, who was a 19-year-old teenager, who was one of the members of the Oneg Shabbat archive in the Warsaw Ghetto. And that archive too was buried in the ground. And he wrote a note that was found later with the crates in which the archives were buried. And he wrote, "What we were unable to cry and shriek out to the world, we buried in the ground. I would love to see the moment in which the great treasure will be dug up and scream the truth at the world. So the world may know all, so the ones who did not live through it may be glad. May the treasure fall into good hands, may it last into better times, may it alarm and alert the world to what happened in the 20th century. May history attest for us." So this was the meta-narrative, to affect history, to affect social memory, to affect the intergenerational memory. And of course, this is a translation into English. It was originally written in Yiddish. Now, so just to sum up, this sentiment of affecting, of documenting and disseminating and affecting future memory is not consistent with the underlying meta-narrative of the copyright regime, which is control over dissemination. As one Holocaust researcher described it, when we look at victims' works, these people were sending us a letter in a bottle. So here is one tension, but when we look at works created by the Nazi regime, we see the mirror image of this tension. And here the anomality results from the ordinary and normal application of copyright law to these materials, as if they were regular works of authorship which copyright law is designed to promote. So just to give you some examples, European archives that hold the rights to footage, the copyright to footage depicting the actual genocide, the actual extermination. Very, very difficult to watch. These archives charge regular royalties, which may amount to thousands of dollars per minute for the use of these materials. Another example, Triumph of the Will, this famous propaganda film, was used by a director several years after the war. A director took segments from Triumph of the Will and contrasted it, the marching crowds, with the footage from concentration camps. And he was sued for copyright infringement by Leni Riefenstahl, by the director of Triumph of the Will. And Riefenstahl, in her memoir, writes, Minerva, which was the production company, would either have to remove the sequences taken from my film, or else, as was normal, obtain the rights. And indeed, a German court upheld that this was a copyright infringement. And according to reports, the film Triumph of the Will still generates royalty payments to this date. Another example, an American judgment from 1932 in the case of Mifflin versus Stackpole. Mifflin was the publisher of the authorized version of Mein Kampf, the authorized translation, English translation of Mein Kampf in the United States under a contract with the Hitler-controlled publisher. And Mifflin sued Stackpole, which issued another edition of Mein Kampf, which was not not translated under the supervision of Hitler, but contained a full translation of the work. And they were sued for copyright infringement. And an American court indeed held that this was a copyright infringement, which entitles the plaintiffs to regular copyright remedies, that Mein Kampf was a copyright protected work. And the argument that the publication of the full uncensored translation was something of social value was rejected by the American court. So regular copyright applies. And last example from several years ago, the heirs of Joseph Goebbels sued a researcher that published segments of the Goebbels diaries as part of his research for copyright infringement, and were successful in a German court, which again rejected the contention that because of the immorality of the work, regular copyright should not apply, and copyright was upheld again. So again, in all these cases, affording these works regular protection of copyright gives the perpetrators or their successors with control over the memory of the Holocaust, over what can be said about the Holocaust. And in addition, granting these works with a stamp of authorship, we argue, normalizes, has a normalizing effect, aestheticizes the works and sort of blurs their immoral content. So again, a dissonance between ordinary copyright protection and those Holocaust-related materials. If we delve even deeper into copyright doctrine, we find other conflicts. So for example, usually copyright maintains that the author has the right to decide when and if to publish the work. So if the work is published without the author's consent, then this will likely yield a result of a holding of copyright infringement, and this decreases the chances that an argument of fair use is the principal defense against copyright infringement. So this decreases the chances of fair use being held. So, but when we look at Holocaust-related materials created by victims, then publication during the Holocaust was really not an option. Rather, the only way to ensure that these materials will ever reach an audience was to conceal them. So the history of the Kovnopolis and the Oneg Shabbat archives were buried in the ground. And the the Grossman photo collection, which we saw earlier, parts of which we saw earlier, was hidden under a windowsill. And there were even manuscripts that were found concealed under the ashes in the crematoria of Auschwitz-Birkenau. So in all these cases, the victims during the Holocaust concealed their materials, concealed the works in order to ensure or to give them a chance to reach an audience at some future time. However, when we apply the ordinary copyright doctrine, then this renders these works unpublished works and decreases the chances of fair use and increases the chances that publishing these works would be held copyright infringement. And again, paradoxically, this results in reluctance of usually Holocaust museums to publish those works, which is exactly contrary to the wishes of their creators. Another area of mismatch or conflict is revealed when we consider the weight which copyright law places on transformative and partial copying. Usually under the fair use doctrine, again, this defense against copyright infringement, the fact that the work is used in its entirety and without transformation decreases the chances that the use would be found fair, and increases again the chances of chances that copyright infringement would be found. But again, when we are considering the collective memory of the Holocaust, then access to complete, authentic, unchanged, untransformed works is crucial in order to overcome, or not overcome, but mitigate the Holocaust's problem of representation. So describing the Holocaust in paraphrases or summing up materials is not equivalent in terms of the effect to granting access or publishing or digitizing authentic materials from inside the event. And in addition, if someone wishes to make a transformative use of Holocaust-related materials, they would first need access to the original authentic materials. But this access usually depends on Holocaust remembrance institutions, Holocaust museums digitizing those materials, because as I mentioned, usually these materials are not out there in the market. So for example, you can see here an example from this artistic project called the Holocaust project, created by an artist called Shachak Shapira. He took selfies, I think he took them from social media. He took selfies that were taken at the Holocaust Memorial in Berlin. And then he merged them with authentic photos from Auschwitz-Birkenau. And this would likely be considered a transformative use. But in order to be able to make this transformative use, these photos should be accessible online. So, and accessible online as is. So copyright's emphasis on transformation may trump, first of all, access to the authentic materials. And secondly, those secondary transformative uses, as we can see here. And finally, there is a well-known problem in copyright law concerning orphan works. By orphan works, we mean works whose authors are unknown or unreachable. Now, this issue of what can we do with orphan works when we don't know who the copyright owner is, we don't know who to turn to in order to ask for permission to use the work. The question becomes really acute, usually with respect to museums who wish to digitize masses of collections, their entire collections, and the collections contain orphan works. So this is a very debatable issue. In several in European countries, in Israel, there is specific legislation within the Copyright Act that handles orphan works. But in the United States, for example, the ordinary copyright applies to orphan works in the sense that the requirement that the author must authorize and give permission to the use of the works applies. But if we are dealing with works whose authors are unknown, of course, this means that use of the work becomes impractical, unfeasible. Now, again, this is not a problem that is unique to Holocaust-related materials, but it is exacerbated and brought to the extreme with respect to the Holocaust because of the masses of, because of the masses of orphan works, because of the magnitude of the genocide. There's a huge amount of victims' works whose authors are unknown and unreachable and were most likely murdered and cannot be reached and cannot be identified. So getting their permission is really not a viable option. And in addition, we have to remember that the entities that have to deal with these orphan works are the Holocaust remembrance institutions, are the Holocaust museums who can digitize those collections, those entire collections. But as we were saying, those institutions are likely to be risk averse and not assume the risk of copyright infringement, even though this risk is small. So the subsistence of copyright in these masses of anonymous work might just freeze those entire collections and keep them in the file drawer. In the file drawer, I mean, not online, prevent the museums from digitizing them and they remain inaccessible, largely inaccessible. And there is some evidence that this is actually happening. We saw earlier the testimony of the US Holocaust Memorial Museum, and Guy and I have been interviewing Holocaust museums worldwide to understand what their policies are in such cases. So if we take all those attributes combined together, we believe the effect of copyright law over the collective intergenerational memory of the Holocaust, although unnoticed, is actually quite significant. So what do we do about it? So on the more normative level, we believe that copyright should not just remain oblivious to this impact on the Holocaust collective memory, and we try to suggest several recommendations how to calibrate copyright doctrine with the realities of the Holocaust without need for extensive changes in the legislation, just by applying and interpreting existing copyright doctrine. So here are our main proposals. First of all, the doctrine of implied license. Implied license means that in certain cases, even though an explicit license, an explicit permission was not given by the copyright owner, a court may be willing to imply a license to use a certain work. So we suggest that the doctrine of implied license should apply to anonymous works of Holocaust victims. This would enable certain uses and certain dissemination of these works and would allow to treat them as they actually were, as a letter in a bottle addressed to the future generations. Now, applying the implied license doctrine to Holocaust-related materials does require some stretching in the current interpretation of the doctrine. We are aware of that. I will not get into the technical details, but we do believe that such a broad interpretation is possible and is justified in the case of those works created by anonymous victims. Secondly, we propose to recognize that Nazi materials are a category within the doctrine of the framework of a doctrine called copyright misuse. Copyright misuse means that in exceptional circumstances, copyright should withdraw in favor of the public interest. Now, the doctrine of copyright misuse is suitable here because the focus here is on the unjust, on unequitable conduct of the copyright owners. So it sort of embeds this expressive element of delegitimizing the behavior of the copyright owner. And so if we apply it to Nazi materials, it can decrease the control of the successors of the Nazi regime over the memory of the Holocaust. And finally, of course, we also propose to calibrate the fair use doctrine in several ways. For example, to recognize that the unpublished nature of Holocaust-related materials created by victims does not or should not bar a finding of fair use, or that the digitization of entire collections of those anonymous works by Holocaust remembrance institutions, again, should not conflict or should not bar a fair use finding. So just to conclude, we hope to shed light on the impact of copyright on the collective memory of the Holocaust. We hope this research will add to the vast amount of research on what shapes or how the collective memory of the Holocaust is shaped among various communities. And we hope that illuminating copyright's shortcomings in this respect would lead to some calibrations of copyright doctrine, and possibly this research may also have possible implications for additional cases of genocide. So thank you. I will stop here. I will present to you the second CLE code word. And then I'll be happy to take some questions.
Thank you so much for that presentation, Professor. I'm going to combine two sort of questions into one because they're asking almost the same thing. So why doesn't the doctrine of fair use permit profit-free dissemination of Holocaust materials? And then to piggyback off of that, can't museums that are charities and theoretically non-profit publish Holocaust manuscripts under the fair use doctrine?
So the issue of the fair use doctrine, actually, the jurisprudence surrounding the fair use doctrine is quite vast and quite complicated. But just to give the short answer, the nature of the use is one of the factors that determine fair use or that impact fair use. But the question of for or not for profit is not the sole question, and in recent years, the more decisive factor here is the question of transformative versus non-transformative. So if the digitization of a collection, which is of course non-transformative because it has to be true to the original, right? It has to reflect the original documents. Then this non-transformation may weigh more than the fact that this is a museum and generally which generally operates not for profit. The question of profit is tricky because not paying a license fee may be interpreted by some courts or in some context as something monetary that affects the question of profit. So it's not decisive, and the fact that these are not-for-profit entities that does not solve the problem for these remembrance institutions.
Next question, whose copyright is being violated for orphan works?
I think that's a wonderful question, and I've been thinking about this question extensively, because assuming that these people were murdered during the Holocaust, then whose copyright is it? Now, it may be that some of the people who were murdered had heirs and the heirs survived. It may be that they did not have heirs. It may be that there's by some complicated web of provisions of jurisprudence in some jurisdictions, the entity that can voice these claims is some sort of custodian appointed by the state. I don't have a definitive answer here because as far as we have been able to, I'm being careful here, but because we have been conducting this empirical research and we have been interviewing dozens of Holocaust remembrance institutions, and as far as we know, actual claims were not filed, but there's always this theoretical possibility that the anonymous person survived or had heirs who survived, and the heirs and the work is still under copyright, and the heirs would file a claim.
Thank you for that. In light of recent events in the world, isn't it more vital now than ever to digitize everything? And if so, would those digitized materials potentially be considered inauthentic in the future should the originals be destroyed?
I'm not sure I understand the question. The first part, recent events in the world, I think, well, I'll begin with the second part. I think it's crucial to digitize everything, as the person asking the question put it, everything from the Holocaust period. Yes, because we are moving, or we are already in an era in which materials that are not out there accessible on the internet are relegated to the fringes of collective memory. Okay, they exist in the museum, but the number of people who can access them in the museum is very limited in comparison to people who can access them online. And I think museums and remembrance institutions are very aware of that, and this is their ultimate goal. So yes, I believe that in this digital era, it's very, very important to digitize everything. As to the reference to recent events in the world, I'm not sure about what the question, the person asking the question had in mind, but we were trying to think whether today, things happening today may have similar attributes. And of course, this requires a thorough research, but I believe that today with the internet and digitization and everyone having a cellular phone, in which they can take photos and the videos and put content online. This pressing sentiment, which we see coming through the victims' works, the Holocaust victims' works, that the world will not know what happened. I think this is largely no longer valid, because the chances that the world will not know what happens in some corner of the world, of atrocities, of genocide, of other problematic things are lower today than they were in the midst of the 20th century, where photography and film technology was available, but not the internet, not digital technology. They answered the question that was not asked, but
yes. So how do the mechanics of the 1909 Act bear on the analysis of these materials, since with the concealment, so much of this material has not actually been published yet?
We did look at the previous act, and we did look at the current act. At least the way we understand the web of provisions, I think it's section 302 to 304 of the copyright of the 1976 Copyright Act. The unpublished works that are anonymous are still protected, because the term of protection extends up to 120 years from the creation of the work. So we believe these are the relevant provisions applying to those victims' works.
Since a lot of the people who survived the Holocaust, are getting up there in age, and their children, shouldn't anonymous photos be made available to be identified now before those that have the potential to ID them will be gone?
I completely agree. This is, one of the motivations for this project and for the recommendations we put forward. As I mentioned, we have another part of the project where we have been interviewing Holocaust museums in order to try and understand how does copyright affect their day-to-day management of those materials. So hopefully, and we have been speaking to the Holocaust Memorial Museum and the Weiner Library in London, and the Shoah Memorial in Paris, and the dozens of additional museums and remembrance institutions and archives. And one of the hopefully one of the objectives of this research and the additional parts of our large-scale project is to help those institutions in our interpretation of the Copyright Act, and in digitizing and preserving all those photos and additional Holocaust-related materials.
In terms of photos taken during the Holocaust by the German army or the German government, who retains the rights to those materials? Is that owned still by the German government? And is there a policy about usage of those materials?
So again, I will be careful here, but largely the German Federal Archive holds the rights to a very large number of photos and footage and other documents that were created by soldiers during the Holocaust. Again, we have been interviewing institutions, and hopefully we will also be speaking to the Federal Archives in the year to come. But our impression is that these materials are treated like ordinary materials. And sometimes, yes, there has to be some payment for the use of these materials by museums or other remembrance institutions. But again, I'm being careful and tentative here. I don't want to make overreach, make overreaching statements here in describing the situation, but this is our impression so far.
Okay, thanks. I think we have time for 2 more questions. So one of those questions will be, is there an area of interest in your research about the copyright of the works by Jewish authors that were sort of plagiarized and had an Aryanization about them by the Nazis during, World War II?
Works of Jewish authors that were plagiarized, it sounds fascinating. We have not touched this in our research, but hopefully there will be more research on it's. The more we delve into it, the more we find there's so much to look at in this area of copyright and the Holocaust. So
Sure.
we have looked at this so far.
Okay, and then one final question. Did the Allies seize the copyrights of any Nazis created works after World War II? And was that done with any patents as well?
Well, as far as copyright is concerned, yes, the short answer is yes. In the United States, there was a general confiscation of materials found, and the copyright was held by the alien property custodian for some time. And then during the 1960s, there was an amendment to the act, and the vast majority of the rights were returned. As far as I remember, this applied also to patents, but I can say this with certainty with regard to copyright. However, there were several exceptions. For example, the rights to Mein Kampf were not returned. The rights in the photos of Heinrich Hoffmann, who was the official photographer of the Nazi regime, were not returned. So these rights were held, and some of them are still under Mein Kampf. Copyright expired several years ago, but until the expiration in 2016, it was held by the United States. At some point, the rights were sold or transferred for payment to Mifflin, who was the official publisher of Hitler before the war, as I mentioned, and the commercialization of the work continued. So the fact that the rights were confiscated does not necessarily imply that these works did not or ceased to become available to the public or ceased to be commercialized.
Thank you very much, Professor. I'm going to turn it back to Dan now.
Thank you, Brandon. And thank you very much, Michal, for your presentation, which was fascinating, moving, and somewhat surprising, at least to me. It's clear that scholarship such as yours is a key reason why the Hebrew University Faculty of Law enjoys the great ranking and reputation that it has internationally. For those of you, I think there are a few people who missed the code words for getting CLE credit for the presentation. Those 2 code words are first copyright and second propaganda. Finally, I'd like to thank Brandon and Lori for their great work putting this together, and particularly to thank Milan Chatterjee, who had the great insight to think of this program and to put together the American Association of Jewish Lawyers and Jurists and the American Friends of Hebrew University for this magnificent collaboration. We look forward to future collaborations, and thank you all for attending. And with that, I think we're done.
Thank you very much. Was glad to join you today.